So the first case to come before the court is Reed versus Sims. And the kid has already informed us that the appellees know to split your time. And so each side will have 15 minutes, and you may reserve up to 5 minutes if you so choose. And we do videotape. I don't think there's an issue with saying kids' names or anything like that in a civil case victims, but at the same rate, I always try to remind everybody that we don't use a victim or a child's name. So, if you're ready to proceed, we're ready to listen.
Good morning. May it please the court, James Burrow on behalf of Derek Reed, the appellant in this matter. If I may, I request to reserve 5 minutes.
Thank you.
This case, for lack of a better term, is a case of a non-convenient forum. The parties were married in Lorain County, divorced in Lorain County, and subsequently father received sole custody and moved with the child to Tennessee. I don't believe there's any dispute between the parties or the court regarding the legal standard that this court has to review, that being abuse of discretion. And I don't believe there's a dispute as to the directive that the lower court had, that the statute ORC 312721, which tells the court when an inconvenient forum applies. The appeal, and where we believe the court erred, is in the application of the facts to those factors. The most glaring of all the factors that we believe is abuse of discretion is, and I step back, Your Honors, the statute doesn't give the court any direction as to which factor is more important or the weight of the factors. It just gives 8 factors and says these are mandatory factors the court must consider. And the trial court went through each of the factors, and it is our contention that each of the factors either are a nullity or support a transfer to Tennessee. But in each of them, the court doesn't specifically tell us what weight they gave. The first factor is domestic violence. What's interesting, and I'm sure you've read this in the briefs, is on 3 separate occasions an attempt was brought to bring evidence regarding potential domestic violence, and the court kept it out for good reason. It was stale evidence or it was not relevant to the current proceedings. So the court never allowed any evidence of domestic violence in the record, but yet in its decision considered it a factor in weighing on keeping the case in Ohio.
Counsel, with the domestic violence testimony, I can't remember. I know some things were stricken, but other things weren't stricken, were they, even though the objection was sustained?
Well, there was 3 attempts, and twice it was the objection was sustained, and once testimony was stricken after she let it come in for a little while, that she struck the testimony. So there was no evidence of any domestic violence, and that sort of begs the question, Your Honor, is that by keeping the evidence out under those circumstances, it didn't give my client an opportunity to refute the allegation. Since there was nothing before the court, there was no reason to explain that it was an untrue statement, that there was no domestic violence. Further, whether there was or there wasn't, there's no evidence in the record that indicates which jurisdiction would be in a better position to deal with domestic violence, for the court to give value to or weight to one side or the other. The clear testimony that was in the record was that this mother had been convicted of an offense of child endangering. So for the relevancy, I would think crimes against a child would have been a factor to keep Tennessee court as the proper jurisdiction, because that's where the child resides. Second factor the court's required to look at is how long the child has been outside of the state. Now, I think Judge Glass took the position as just wait. Well, he lived 5 years in Ohio and 3.5 years in Tennessee, but I think it's an illogical reason for that factor. I think the purpose of that factor was, what ties does the child have to the new state? Has he been there 5 minutes, or is he established? Has he been there? And he had been there for 3.5 years. The 5 years that he was in Ohio would have been his first 5 years of life, and his memories would have been very limited. He wasn't in school. So I think in weighing the two, Tennessee is clearly the more proper venue. Factor 3 and 4, the judge combined, and again, she puts them on an even playing field. We have a custodian and a child in Tennessee versus an unsuitable parent and her parent, grandparent, supervisors. They're not on an even playing field. If we're going to inconvenience somebody, we wouldn't inconvenience the child and the legal custodian. We would either be a tie, or you would look to protecting the child. And that's where I think Judge Glass missed in her analysis is, I think, as many people do, I can handle this, I'll make accommodations, why do I need to transfer it? Looking at whether it was proper for her to hear it or not, rather than looking at it from the child's perspective. The child's going to have to come to Ohio to litigate this. The child's going to have to be disrupted from school. All the witnesses were going to have to come to Ohio. And the case law, as it's in my brief, indicates that the focus is supposed to be on what's best for the child, not what's best for the court, or which judge is willing to bend over backwards for the parties. Next factor was that whether there was an agreement to keep it in Ohio. There wasn't. There was indication that Ohio retained jurisdiction, but that's just the status of the law. There's no question Ohio has jurisdiction. There's no question that Tennessee has jurisdiction. They're concurrent. The question is Ohio going to relinquish, or are they going to hold on to it? So the court never found any agreement, and their analysis is misplaced. They're looking at whether there's jurisdiction. We've never contested whether there's jurisdiction. We just think that it's an inconvenient forum. Factor 6 is what this case is all about. It's the biggest factor by far. It's the factor where the court is asked, where is the nature and location of the evidence required to resolve the pending litigation, including the testimony of the child? Everything's in Tennessee. His school, his teachers, his doctors, his friends, his babysitters. If you had the case in Ohio and you got a guardian ad litem, you're going to send the guardian ad litem to Tennessee to do all that, get all that information? It would be a huge financial burden. It would be a nightmare for discovery to try to get that information. This case belongs in Tennessee because that's where all the evidence is.
Counsel, with an eye toward what was pending when this ruling was made, what, in terms of the guardian ad litem's involvement, was left to do? Everything that had already been researched and not testified to, or had there already been testimony with respect to the guardian ad litem's work prior to this determination?
Thank you. The case was concluded prior to the most recent litigation. Mr. Reed filed in Tennessee to modify the parenting time and the parenting time plan in Tennessee, and then filed a motion to stay Ohio and transfer it to Tennessee. In the meantime, the mother filed some show causes and her own motion to modify the parenting time and schedule. So they've never gotten to the point where whether there be a guardian ad litem appointed or any testimony. It was at the very beginning of the new round of litigation. The interesting one about number 7 is the ability of the court of each state to decide issue expeditiously and the procedures necessary to present the evidence. There's a provision in the law, it's 3127.09, which allows, it actually directs the Ohio court to contact the Tennessee court to see who's in a better position to expeditiously do this and move things along. There's nothing in the record that the two judges ever spoke, and there's nothing in the record that says that Ohio's in a superior position to do anything more expeditiously than the Tennessee court. So I don't know how the court could weigh that factor. And then the last factor is the familiarity with the parties in the litigation. As I indicated in my brief, Judge Boros had this case when custody was granted to my client and when he moved to Tennessee. Judge Glass was new, her magistrates were new to the bench, they're in no greater position to know the facts and circumstances than a Tennessee court. These parties are going to be going before a new judge regardless of where it's heard. Essentially, it's our belief that every factor supports Derek Reed's belief that the case should be where the child is, it should be in Tennessee, and we ask the court to vacate and reverse Judge Glass's ruling. Thank you.
Thank you.
Good morning, Your Honor. My name is Valerie, and I'm representing the Valerie Sims, who's the mother of the case. The UCCJEA that is set out in 3127.01 through 3127.53 provides that since the case originated in Ohio, the parties obtained a divorce in 2012, and the child was born in 2010, all in Ohio. At the time the mother agreed to transfer custody to the father, there were issues with the mother, and that was very clearly laid out in the journal entry of March 3, 2015, where mother was to have counseling, and until the counselor stated that the defendant has an understanding of how her actions have caused SR to be at risk of harm, and further, if defendant is fully committed to protect Spencer from harm and abuse.
Yeah, we just use the initials, or just refer to him as child.
Yes. I apologize.
That's okay.
Such being the case, all of the facts that are needed in order for the mother to modify the supervised state as it is now, all is found to be in Ohio. There's nothing that the mother needs from the state of Tennessee regarding the child. The burden is upon her to present her evidence in order for her to come to the state where she can request unsupervised visitation. And in the meantime, the grandmother has to supervise these visitations, and the child has substantial relationships in Ohio, as both sides of the family, the fathers as well as the mothers, live in Ohio. And now the issue that has risen is, appellant has contended that the consideration given by the court in one of the first factors under 3127.21 has domestic violence occurred, and is it likely to occur in the future, and which state could best protect the child and the parties. It is appellee's contention also, and her position, that Ohio is in a better position. Now, it is true, the court did not allow some of the evidence regarding domestic violence. However, both testimonies by the grandmother and mother were very clear that the mother is afraid of the father. And the grandmother testified that she is afraid for the safety of her daughter when there is a pickup and a drop-off at Kentucky. The father has exhibited a great deal of animosity against the mother, and he has thrown the items of things that the mother had given to the child, including, and I believe the transcript is very clear, the father threw them on the sidewalk and drove away with the child crying inside the vehicle, looking back at the stuff that was on the floor or the sidewalk. Now, whether the appellant was correct in that the statute does not tell the court as to what weight to give each of the factors, and it can give any weight, and it is within their discretion to determine what weight, if any, to be assigned to each of those factors, depending on the facts and circumstances of each case.
The court seemed to hold that, or find that the parties acknowledged or agreed that there was a history of domestic violence in the relationship.
That is correct. That is what the court found. In one of the statements, the judge said, the issue is historical, but I want to know what additional facts you can tell me that is there a violation of any of these orders and that you can tell me now that is occurring. And those were the very facts that was very clearly laid out by the mother, saying what the father's refusal to give her telephone time with a minor child, the father's refusal to talk to the mother to tell her what the schedule is, what time he would be coming. He insists that he does not have to talk to the mother, and he only talks to the grandparents. The child cannot talk to the mother if the mother is not present in the grandmother's house.
Counsel, that seems to go more to failing to cooperate rather than domestic violence.
That is correct. It is a failure to cooperate, but the incidents where a father throws the things and shows anger, doesn't want to speak, and throws things around, those are certain manifestations of domestic violence.
Except that Judge Teodosio's question was, the judge found they had stipulated to the parties or agreed to there was domestic violence. I'm not sure there was any kind of agreement, was there?
There was, the father said that whatever domestic violence that he was charged with was later reduced to a misdemeanor 4. And I do not know whether that was on record or it was off the record. I do not recall at this time. Yes, he did admit to it, but however, during the time of the actual, due to the time of the actual testimony, the counsel kept objecting as to whether to bring what occurred prior to during their relationship, and that was objected to, and which the court sustained. How the court knows if it has been historical, maybe because of the facts that were coming out of the hearing, and maybe it assumed, yes, there was domestic violence. And also, Your Honor, in the, as to the facts, as to number 6 and 7 of the factors, the nature and location of the evidence required to resolve the pending litigation, including the testimony of the child. The child visits Ohio pretty much every month that the mother goes and picks up. Because of a 3-day, if there's a holiday on a Monday and if there's a 3-day time available, then she has that visitation. And it has been pretty much on a monthly basis. And the ability of the court to expeditiously, who can decide the cases expeditiously, and the procedures necessary to present the evidence. There was
Counsel,
testimony.
let me just stop you for a minute, or just for a second.
Yes.
You didn't indicate how much time, so I assumed you two had already split your time. You're already...
I'm already out here and I have to. So I believe, Your Honor, that based upon the testimony and the court did not violate any of its discretion. It was within its right to rule as it did, and it has given a great deal of attention to all of the factors And in addition, it has also considered other relevant factors that is in the best interest of the minor child. Thank you.
Thank you. You have about 6 minutes.
My name is Karen Asbury. I am the maternal grandmother of the child. I am aware there's time frames, so I will try to be brief. Back in August of 2014, my husband and I motioned the court to become third parties in this case. That was granted. We did that because we were being kept away from the child. In July 2015, father put a motion in to reallocate parental rights. Obviously, we all were in court in contested hearings. We also requested a GAL. That was granted. My husband and I were granted by the court 5 weekend visits to the state of Tennessee to see Spencer and to bring his siblings because they live with us. When Spencer was born, he was
Ma'am,
born here
we
in
could
Ohio.
just refer to the, we have to edit out every time somebody mentions the name, so if you
Oh,
could just,
sorry.
that's okay, just refer to
The
the
child,
grandson as a child.
grandson,
Mhm.
yes.
Yeah.
Grandson was born here in Ohio, lived with his brother, his 2 sisters, his mother, and his father at that time, and they all lived with my husband and myself. The child continued to live with us up until July 2014. I want to mention in these hearings that we were a third party to, all parties negotiated with a clear understanding that this court retained jurisdiction to hear any cases, any issues with this case, I'm sorry. And there were many. There still are. It is with that understanding that my husband and I, made sure that we looked at things the way we should, and trusting that this court would retain that jurisdiction to hear the issues. I want to be very clear on that. The grandson has many extended family members here. His mom, his maternal and paternal grandparents, aunts, uncles, cousins, first, second, third generation cousins, great-grandmother. He's very close to them, very connected with them, does many things with them. He also is active in the senior community with his great-grandma. He is also very well established here in the state of Ohio for medical purposes. When he needs medical attention, he has doctors here. He also attends church here, has a church family. My husband and I feel like this court can better handle the situations that seem to keep arising because they know the history, they know the case, and it is a long, complicated one.
Evidently, the Judge Boros had retired, and then Judge Glass won, and they're saying there's new magistrates and everything. So who in the court had a history with your case?
I'm not really sure, to be honest with you, other than, like, you are correct, Debbie Boros was the judge. We don't know, how many times back and forth things were talked and handled, I do know there was the new judge, and I know there's a new magistrate. That magistrate actually used to be our attorney before he became magistrate. He was representing us. So I don't know how all that works in that, but I know he doesn't have anything to do with that now. so, you know, there is some knowledge as to what has taken place. I want to say too, back to the Tennessee visits, we have followed the order, and I will say, Father did too, once that was set in place, up until August of 2019. This school year that we are currently in, we have not been able to utilize those visits because Father will not make the child available to us any longer. So we are concerned about his failure to comply with the court orders, not just there, but in other areas. I do believe the court here is aware of a lot of this. That's why we feel this court is better able to handle the many issues now. And we are tending to believe that there will be more, because we try very hard to follow the court orders, and we're not getting that with everybody. I do want to bring up, I know it's been a little bit discussed, the domestic violence. Yes, I did testify to that. And yes, I'm aware that it was not allowed, but that does not mean it did not happen. And there is a definite pattern that I myself have witnessed over the years of that kind of behavior. And that makes me and my husband very concerned about the safety of Valerie and Spencer as well.
I have to stop you. Thank you. Your time is up.
Thank you very much.
You have your full 5 minutes remaining.
Thank you. A lot of what Ms. Asbury stated is emotional and comes from the heart, but a lot of it's not in the record. There is no indication in the record that there was an agreement at any point in time. In fact, the court never made a determination that there was an agreement. The court went a different way and weighed based upon documents. As I said before, the court analyzed whether the parties stipulated or agreed that Lorain County retained jurisdiction. We don't dispute that. Clearly, Lorain County has jurisdiction. The question is it the more convenient forum or is Tennessee? There's nothing in the record indicating that there was an agreement or that there's any document that suggests that Tennessee can't be considered as a convenient forum.
Well, there is an agreement, but it just says that Lorain County will have jurisdiction.
Just in the agreement that the court refers to is in the dissolution, the shared parenting plan. Dissolution in the shared parenting plan was terminated. So at one time, they said Lorain County would retain jurisdiction, but once the shared parenting plan was terminated, sole custody was given to my client. I think it's a nullity, but they're holding on to that as some indication that Lorain County was to retain jurisdiction. Lorain County has jurisdiction. I think everybody in this room agrees Lorain County has jurisdiction. It's our position. It's not the convenient forum. And this domestic violence thing, we go round and round about it. Council indicates they're doing the pickup and the drop-off in Kentucky. I don't know how it makes Ohio or Tennessee more valuable, or it's a better situation for addressing the domestic violence. And I think the court got it absolutely right here when it's really about inconvenience and the parties not liking each other. It has really nothing to do with domestic violence. This is a case where we have a judge, a very good judge, a very caring judge, but a judge who made a decision based on outcome determinative. She decided, I can keep this case, and then she went through all the factors and took the evidence and tried to fit it in so that she could keep it in Ohio. But all the factors suggest it should be in Tennessee. Most importantly, that the child is in Tennessee and is going to stay in Tennessee. He's going to church there, he's going to Cub Scouts there, he's doing everything there. That's where he lives and that's where he's going to stay. This case properly belongs in Tennessee. And it's been a disservice to all of these people that they've been waiting all this time. This thing could have been litigated already in Tennessee very quickly. Anything that happens in Ohio is going to be a nightmare as far as trying to get documents from Tennessee, witnesses from Tennessee, getting the child here missing school. It properly belongs in Tennessee. Thank you.
Thank you. Appreciate everybody's argument here this morning and your presentation and appearance. The court will take the matter under advisement. We will issue a written opinion that will be sent to both sides, to all parties, I should say. And we also release it on our website and the Supreme Court website. So thank you all very much.
Thank you.
Please be safe going home.